Hello everyone, this is Sandeep Krishna Tulabandula, Regional Head, Regrob, Telangana. I'm back again with an interesting term which is tripartite agreement. I'm sure not everyone will be familiar, but a lot of people who are into real estate industry or who have already bought a house might be familiar with this tripartite agreement. I hope this video will give some brief information on what is this tripartite agreement and how this works. Buyers investing in an under constructing property invariably have to sign tripartite agreement entering into a contract. Since there is a financial institution also involved in the process, there are a total of 3 parties in such an agreement, which gives it this name. What is a tripartite agreement? Terms and conditions of property deals where a financial institution is also involved apart from buyer and seller, typically are laid under a different legal document, legally known as a tripartite agreement. A tripartite agreement has to be signed by these 3 parties when a buyer opts for a home loan to purchase house in an under construction project. Tripartite agreement have been established to assist buyers who are requiring loans against against the properties, since home or apartments are still not in the name of customer until the possession. The builder is included within the agreement of the bank. In the leasing industry, tripartite agreement can be drafted among the lender, the owner, and the tenant. These agreements usually state that the owner or the borrower in breach of the non-payment of the loan payment, the mortgage or the lender becomes the new owner of the property. Furthermore, the tenants will have to accept the mortgager or the lender as the new owner. The agreement also restricts the new owner from changing any clauses or provisions of the tenants. Tripartite agreements should contain a particulars of subject of property and should include all the annex of property documents. Also, tripartite agreement needs to be relevantly stamped and subjected to the state where the property is located. Details the tripartite agreements should have to carry, and also the information should be established, are names of the parties in the agreement, the objective of the agreement, rights and remedies of the parties, legal implications, the borrower's perspective, the developer's perspective, banks or lenders' perspective, agreed selling price, date of possession, stages and the progress details of construction, interest rates as applicable, equal monthly installments, which is EMI details, agreed common area and amenities, penalty details if the agreement is cancelled, and tripartite agreement should replicate developer or the seller's document has a clear title. Furthermore, it should also mention that the developer has not entered into any new agreement for sale property with any other parties. For instance, the Maharashtra Ownership of Flats Act 1963 requires the sellers and developers to the buyers share all details which are relevant to the purchase property. The tripartite agreement should also contain the developer's liabilities to construct the buildings as per the approved plans, and it should also specify all the terms and conditions by the local authority. Terms and conditions in such agreements should be careful and therefore might be difficult to understand. It is advised that the buyers seek the assistance of legal experts to look into the documents. Not doing so might lead to several complications in future, especially in case of a dispute or project delays. So I hope this video might have given some brief understanding on this tripartite agreement. If you do have any questions, do comment on this video. Subscribe to Regrob for more interesting real estate content. Stay tuned.